Hello, Tungol Law family and friends, and happy Thanksgiving. We hope that you and yours are keeping well and healthy amid this pandemic, especially during the holiday season. On this show, we welcome intellectual property attorney Kattina v. Barsik Esquire. We'll talk to her a little later. But for now, here are your three top immigration news. Topic number 1, federal judge ruled the Trump administration DACA order was illegal. Topic number 2, new restrictions on F, J, and I non-immigrant visa categories. And topic number 3, DHS extends flexibility in requirements related to Form I-9 compliance. Now, the federal judge ruled recently that the Trump administration's DACA order was illegal. You remember that the U.S. Supreme Court ruled a few months ago in June 2020, which states that the Trump administration's attempt to cancel deferred action for childhood arrivals, or DACA, were unlawful. Hence, the DACA program was supposed to resume. Now, instead, the U.S. Department of Homeland Security, or DHS, announced that the new DACA applications would not be granted, and that acting DHS Secretary Chad Wolf had made other interim changes to DACA through a memorandum issued on July 28, 2020. Furthermore, Secretary Wolf was considering to fully rescind or get rid of the DACA program altogether. This did not bode well for many people, and as a response, 17 attorney generals from across the nation filed a federal lawsuit against President Donald Trump, DHS, and acting DHS Secretary Chad Wolf, U.S. Citizenship and Immigration Services, or USCIS, and U.S. Immigration and Customs Enforcement, or ICE, asking the court to vacate the July 28th Wolf memo as unlawful. And guess what? They won. Access the court's full decision right here. This ruling meant that the Wolf memo was invalid since acting Secretary Wolf was never lawfully served in the role as acting DHS Secretary. There was a different lawsuit altogether about this issue, and the judge in that lawsuit ruled that Wolf was unlawfully assigned to that role of acting secretary at DHS. President-elect Joe Biden said he will reinstate DACA within his first 100 days in office. So hopefully this will include new DACA applicants. Topic number 2, new restrictions in F, J, and I non-immigrant visas categories. DHS is proposing changes to visas for students, or F1, exchange visitors, or J1, and foreign media, or I, non-immigrant visa categories. Now, the new rule would require a fixed period of stay, a departure from the current policy that allows these types of visa holders to remain in the U.S. for what's called a duration of stay, or as long as they maintain compliance with the terms of admission. The proposed rule comes months after the DHS announced, then rescinded, restrictions that would have forced international students already in the U.S. to leave the country or risk deportation if their university switched to online-only courses. Facing legal challenges and widespread criticism, officials walked back that proposal. Now that rule only applies to new students trying to come to the U.S. rather than students already inside the country. Under the proposed change, those entering the United States under these non-immigrant categories would be admitted up to the end of their program, not to exceed 4 years. Click here for the full text of the DHS proposed rule. Now on to topic number 3, DHS extends flexibility in requirements relating to Form I-9 compliance. Finally, a welcome bit of good news as U.S. Department of Homeland Security, or DHS, announced it will continue to be flexible with Form I-9 employment eligibility verification compliance until the end of the year, or December 31st, 2020, due to the COVID pandemic. E-Verify participants who meet the criteria and choose the remote inspection option should continue to follow current guidelines and create cases for their new hires within 3 business days from the date of hire. You can see the full COVID-19 webpage here on this link for more information. And also you can see the full text of the DHS new release information and how to comply with this flexible Form I-9 requirements right here. So there you have it, folks, our 3 top immigration news. There's a PDF containing all these websites that's available for you if you just click on the PDF link on the intro section on immigration issues. And now on to a special part of our show. We welcome a wonderful friend, a special guest, an esteemed colleague who specializes in intellectual property law. Kattina V. Barsik Esquire is an intellectual property and registered patent attorney. Her practice includes advising clients on the scope and validity of patent, trademark, and copyright issues, as well as litigating on their behalf. Kattina grew up in the Lehigh Valley and received her Bachelor of Science in Genetic Engineering at Cedar Crest College in Allentown, Pennsylvania. Upon graduation, she accepted a research position at Wake Forest University Medical Hospital, where she worked in their comparative medicine department before deciding to attend law school. She graduated from the John Marshall Law School in Chicago, Illinois, where she received both her J.D. and L.L.M. in intellectual property law. Attorney Barsik is a licensed attorney in New Jersey and before the United States Patent and Trademark Office. She's a member of the New Jersey Volunteer Lawyers for the Arts and the New Jersey Bar Association. Welcome, Kattina.
Thank you, Kristine. Good afternoon. How are you guys doing over there today?
We are wonderful. How are you doing?
I'm doing well, thank you. Everything is going well over here, and things have been pretty busy lately in spite of, this COVID crisis we're dealing with.
Well, speaking with the COVID crisis, we would like to focus this topic on trademark and copyrights. As we see that there are more and more people starting their own business or staying home and becoming new entrepreneurs. So let's talk about trademark versus copyright. First question off the bat, what is the difference between trademark versus copyright?
Sure. So a trademark is a mark or a word that would be protected for a commercial purpose. If you have a product that you want to put out, like Coca-Cola, that's a trademark for the sodas. If you have a service, you could be a realtor and you have a certain name and logo that goes along with your business, you could protect that under trademark. For a copyright, that really covers any sort of artistic expression. So your paintings, songs, books, those are all things that you would protect with a copyright, any sort of artistic expression.
Okay, great. So let's tackle trademark first. What are the steps you need to take to apply for a trademark?
Okay, so the first thing I always ask my clients is, what is it that you want to protect? You have a name. Usually they have a name and a logo, but they don't always pay attention to the logo, but the logo is very important because especially if you have a name that maybe isn't so unique or sounds slightly descriptive of the product or the service, it's really important to have a logo associated with that because that will set you apart and make you visually distinct. So I always recommend to people, if you have a logo, let's protect it with that name. And whether it's for a product or a service that you're putting out, that will give you a higher rate of success in the trademark office. And then, of course, something that I need from my clients would be a JPEG version of their name or logo. And I'll ask them whether or not there's a specific color scheme that they use, or if they use it in a variety of different ways. Because really, if you could file it as a black and white version, that will give you the broadest amount of protection. And if you decide to change the colors, with your advertising or something, you're not then losing protection because you only protected a specific color scheme.
That's interesting. So a black and white of your logo is actually much better and gives you flexibility down the line should you decide to change the colors, but not the style itself.
Correct.
Okay.
So the style, the name has to all stay the same. But if you have, maybe you're using purple and then in a couple of years, you decide, oh, you know what, we want to use green. You could do that, and it won't be an issue. It won't affect your trademark if you protected that word and that logo image as a black and white from the beginning. So I usually recommend that.
Great. So where do you file it by mail? Do you file it online? I mean, where do they go?
You could do both, but the trademark office gives you a discounted filing fee rate if you do it online, because they're really trying to discourage all the paper coming in. So if you do it by paper, it's $325 versus filing online, it's $225 per category. So it's a big difference. So I always recommend to people, because I do try to help my clients to be cost effective when we do things, to do the $225, and then everything will be done electronically, and then the correspondence has to be done electronically, which isn't a big deal. I mean, it comes to your email, so it's not the biggest deal in the world.
Great.
The other thing is, if it's a mark that you're using currently, I usually ask my clients for a PDF, because that's what the trademark office requires, a PDF of any type of advertising materials that you have for your mark that you're currently using. Now, if it's not something that you're currently using because you wanted to file ahead of time before you launch anything, you could file what's called an intent to use file, and then application, and then you will have to provide that PDF proof of use showing advertising about 9 months down the road.
So currently you're saying it takes about 9 months or maybe even more now with COVID to complete this application?
Absolutely, yes. I would say prepare yourself for 9 months to a year to get that certificate.
So in a nutshell, what are key things for these entrepreneurs to remember when they apply for trademark?
So one of the key things you want to remember when you are filing for a trademark is know what it is you want to protect in terms of how you use your mark and how it looks like. The other thing is, I always tell people, you have to be realistic about the categories, what you're actually doing or what you might be doing in the immediate future. Because one problem that I see sometimes, I have clients who they'll come to me and they want to register something in a whole bunch of categories, but they don't realize that all these categories are not related to each other, and the office will charge you $225 per category, and they may not even be using all these categories immediately with their mark. So let's say they want to sell t-shirts, and then they come to me and say, well, I want to sell t-shirts and hats and keychains and all these things, but really right now they're just doing t-shirts, and they may not even know when they're going to be doing hats and keychains. I tell them, don't file in those categories if you are not doing it right now, or you're not prepared to do it within a year. Because even if we file that intent to use application, you're going to have to show proof of use within a year that you are going to be putting these products on the market. So if you don't think within a year that you're going to be putting those products out with your mark, just wait. You could always file later in those categories, but you don't want to put all this money in up front for something that you may end up not even using at the end.
Great. Now, trademark to protect your logo, to protect your business. How far does that protection coverage go for if you apply for a trademark here in the US?
Are you talking about like a time frame of coverage?
The coverage in the map area.
Okay, so you would be protected across the United States. So anywhere within the United States. You do not have international coverage. And I don't really recommend that for a lot of my clients, because they're either small business owners or small companies. And if you're not selling internationally and you don't really have a lot of money to spend, it's going to be really cost prohibitive to go and start filing applications outside of the US to cover your trademark.
Okay, great. And when you said time frame, how long does this coverage usually last?
So a trademark can last indefinitely, which is one of the benefits, is that you don't have a limit, but they do want you to file a continued proof of use and a maintenance fee every 10 years. So you have it for 10-year increments and you just have to keep renewing it. So if your company lasts, for years and years, and maybe you pass it on to your kids, they could keep that trademark. It's never going to expire. They just have to maintain it.
That's good news. No, well, that's trademark. I know it's a lot more complicated than that, but you really have broken down the essentials in a nutshell, and we appreciate you for doing that for our entrepreneurs. Now let's talk about copyright. What is the process?
So the copyright process is a lot simpler. If you want to do a copyright, you just have to go onto their online system and you fill out an application depending on what type of work it is. So if it's a book, they have an application for literary works, and you will go in, you fill out all your information. They'll ask you for your name, the title of the work, your birthday, when you created the work, when it was completed, and then you will upload that manuscript and go through the different steps in their online system and then file it. And right now they're only charging $65 for an online filing, and for a paper filing it's $85. So it's a lot cheaper than doing a trademark.
Yes.
The other thing is you really don't hear anything from the Copyright Office if there's no issue. Your application will just kind of go along over the course of a year, and then in the mail one day you'll just get that certificate. They do say right now that if you're doing the online system, it is supposed to be a little bit faster. They said that that reduces the time frame to 6 months versus a year. However, now with the COVID crisis going on and the pandemic, I really don't think that's going to happen. I think it pushed probably those deadlines and issue times back to 1 year again, because everybody's working from home, they're overwhelmed. Every time I talk to someone from the office, they're always telling me how they've been working from home since March, and they're not really processing things as quickly as they used to when they were in the office. So there is a little bit of a lag time that you have to keep in mind, but I would say a year is about average on getting your certificate.
And so you get the certificate, does it expire as well?
So copyright is a little different. It's your lifetime. So the author's lifetime plus 70 years. So it does expire at some point. But if you're a young author, it's your lifetime plus another 70 years. So that could go for quite some time.
And around the US and the world, how far does this protection afford you?
So the Copyright Office will protect you within the United States. Again, if you want to file outside of the United States, then that'll be a little bit more costly because you'll have to engage a lawyer and pay the fees for other countries and have to register in all those different countries that you want protection.
Now, why is copyright important?
So copyright is important because as an artist, you want to be able to protect yourself and protect that hard work. And we all know artists are famous for being copied. Priceless works of art are always being copied. How many versions of the Mona Lisa are out there? You want to make sure that nobody comes and copies and piggybacks off of your hard work to make money for themselves. You, as the author, creator, has the exclusive right to make money from your own work. So you don't want to leave yourself open and vulnerable for someone to come along and steal your work.
Gotcha. Your hard work at that for either copyright or trademark, correct?
Absolutely.
Now, is there anything else you want to add when it comes to trademarking or copywriting one's work?
Well, the one thing I think is really important, and the main takeaway from this, is that when you create something, whether it's the name of your business or the logo that goes along with it for your service or your product, or whether it's your copyright, your artistic work, you want to make sure that you protect that as soon as possible. You want to be the first one to file. You don't want somebody else to see what you've created and then now go and copy that. If you've been in business already, you want to think about, maybe I should protect this. If you have, if you've built up a big amount of clientele and you have a lot of goodwill associated with your business, you don't want someone to come along and now piggyback off of that and take business away from you by trying to make something that looks similar to you or using the same name as you, and people then now being confused and not knowing the difference between you, who is the original, versus this counterfeit person. So it's very important that you do go ahead and you do protect yourself right away.
Can they file it on their own, or what's the benefit of going to see an attorney?
So obviously for any of these things, you are absolutely able to do it on your own. But do I recommend that? No. There is definitely benefits to having an expert guide you through these processes and go through and help you with the filings, because not only can they sometimes save you money, because if you don't know what you're doing, you might put things in a bunch of categories that you didn't need. The other thing is they could tell you the best way to go about things. I mean, I can give you an example I just had this week. I had a client come to me and say, I have a collection of poems. They're about there were about 422 poems, but he didn't tell me that initially. He just said, I have a collection of poems. I want to protect them by copyright. I want to do, an application under a group registration. So I said, okay, that's not a problem. How many poems do you have? And he said, about 422. I said, okay, well, the Copyright Office only accepts 10 at a time. So now you're going to pay that $65 application fee for every 10 poems. I said, I don't think that's the best way to go about it, because it's going to cost you a fortune. I said, why don't we do this? Why don't we make it a book of poems? It'll be a whole book, a manuscript we'll put together. If you have a title for the work, you could give that to me now and just type it up as a manuscript. And then at least then you can protect all of your work under one filing fee, rather than going in and spending money on multiple applications that you don't really need to do it that way.
Now that's brilliant. Not only do they benefit from getting an attorney, but it has to be a specific attorney, one with experience, and especially in this type of law, in intellectual property law that covers trademark and copyright, correct?
Absolutely. Whether it's patents and trademarks or copyrights or immigration law or contract law, whatever your issue is, go to an attorney who deals with that topic on a daily basis. And I also recommend people to go to smaller firms, whether it's a small law firm, boutique firm, or a solo practitioner, but people who are doing this all the time, and this is their main focus, because they have the experience and they know the ins and outs. If you go to a large law firm, not only are you paying double or triple the prices, you also are not getting the expertise of the partner who does have the experience, because they're too busy going out trying to get business for the firm. They end up giving your case to somebody who is a little bit lower down on the totem pole, who might just be there a few years, and they might be doing a variety of different types of law, and they may not know all those ins and outs that somebody who specializes in that area of the law knows. So
Gotcha.
I highly, highly recommend to people to always go to somebody that knows that type of law that you're dealing with. and who does it on a regular basis.
And I know I can speak from experience. I've referred many of people to you on this type of law. Now you specialize in this type of law. How can people contact you?
So I have a website. It's called www.barsiclaw.com. I have a Facebook page, Barsik Law, and my phone number, 484-553-1054. And I have an email, Kattina@barsiclaw.com.
Great. So that's wonderful. And again, do you have any Thanksgiving coming, and your family who also are like dear friends and family, extended family to us, would you like to say hello to them?
Absolutely. I'd like to say hello and thank you to my wonderful husband who took my kids today so I can do this interview.
That's wonderful. He is always helpful, that husband of yours, and your wonderful kids. So happy Thanksgiving, Kattina. Many thanks. Yes, many thanks to you and all those important nuggets of information, especially for a lot of people who are starting their businesses or who may currently have their businesses but have not thought about applying or filing for trademark, or having that important and hard work of art, getting a copyright for it. So thank you so much for gracing us with your presence today. It's always a pleasure speaking with you, my dear friend.
You too.
And happy Thanksgiving to you and your family.
Thank you. Happy Thanksgiving.
So there you have it, ladies and gentlemen, folks. We hope that you have learned much today about how to register the trademark or copyright of your hard work. Do it now if you haven't done so. Until next time, we wish you good health and sound spirit. Thank you for listening and watching us today. Now, don't forget, please, to go ahead and subscribe to our YouTube channel by clicking on subscribe. You may also catch us at our website, tungollaw.com. We're on Facebook with Tungol Law Office, and we're also on Twitter. Thank you so much, so long, and have a safe and wonderful Thanksgiving.